I'm Larry O'Connor alongside Brian Wilson.
Well, a big decision yesterday, or I guess it was not really a decision at all, and that's also interesting news from the Supreme Court regarding the contraception case involving the Little Sisters of the Poor, Catholic charity, and they employ some people, and under the Affordable Care Act, the Obamacare, they were going to be required to provide contraceptive for their employees, even though it's against the teachings of the Catholic Church. And so this all makes its way to the high court, and yesterday, sort of a non-decision, and it's complex. And when we have complex non- or legal decisions, we turn to Ken Klukowski, our legal analyst. He's with Breitbart. Good morning to you, Ken.
Good morning, Brian. Good morning to you too, Larry.
Hey.
Thanks for having me.
All right, so as I understand it, they basically sent this back to the lower court without a decision. But it's sort of an interesting way in that they did that they said, look, we think there is the making of a compromise here. You guys go figure it out. Is that what they did?
In a way, this was a fascinating decision. To the extent that there is any victory in this case, it would be for the religious employers, because the court did include that in vacating all the judgments in the lower courts, that it was wiping out all of the penalties and fines that had been accruing all this time to the tunes of many tens of millions of dollars. All of that has been wiped out for all the parties to this litigation and will continue to be wiped out until this matter is resolved. So in that regard, there is a victory in that these religious employers are no longer under this sword of Damocles that was growing over their head every day. But that aside, you're right. This was punting the football until after the 2016 election. The court, in a very unusual move, I mean, I was in the courthouse when the case was argued. People I know were arguing the case. After the case was argued, the Supreme Court ordered supplemental briefing, asking, in essence, to explore if there would be possible to have a compromise, if you could cut the religious employer out of the process by which employees were receiving abortion and birth control related products and services, whether there would be a way to get those products and services to these employees directly without making the employer sign a form or do anything else that was making them complicit in this. The Supreme Court itself crafted this compromise, or got the contours out, when both sides, both the Obama administration and the religious employers, said, well, we think that might be possible. We can see aspects of that we could all live with. That's when the court said, great, unanimously, we are vacating, meaning wiping out all the decisions in the lower courts. The facts have now changed, new arguments are called for, and we're going to send it back down to the lower courts for you guys to hash it out.
And the bottom line is this is part of the compromise that is required because we have a 4-4 Supreme Court, and if Antonin Scalia were still on the bench, this might have been decided very differently.
I think you're exactly right, Brian. I suspect, we have no way of knowing. The justices know, and the clerks, the law clerks who served there this year are knowing, but they're sworn to secrecy, so we'll never find out from them. It is quite possible, I suspect, that if Justice Scalia were still alive, that we would have gotten a 5-4 decision that it does substantially burden these religious employers, the Little Sisters of the Poor, East Texas Baptist University, all of these different employers, that it does substantially burden their religious faith to make them sign forms that they know impose an obligation on a third-party insurance company to pay for abortions, and that this is not the least restrictive means to achieve any compelling national interest. So, in other words, at bottom, is that this Obamacare rule, I believe, is likely to be struck down, would have been, as violating the Religious Freedom Restoration Act, RFRA. And if that's the case, then conservatives lost out on a huge victory yesterday. On the flip side, there might have been a couple swing votes on that. We don't know where Justice Kennedy stood on this issue. We don't even know necessarily where Chief Justice Roberts stood. Maybe Obama was going to win. I don't know. But the bottom line is that the Supreme Court, Paul Clement, the famous Supreme Court lawyer who argued part of this case, he said after argument at a lunch that some of us attended that he thought in this atmosphere the court would really try to find if there was any common ground they could agree upon to avoid just a tie vote in this case. And it looks like they did that, and they managed to do this unanimously, and it shows that the court is able to function perfectly well with just 8 members, while the nation has a conversation about what sort of justice they want to replace Justice Scalia.
Ken, that is a great point, actually. But maybe I'm a relentlessly optimistic guy, but
You're crazy optimistic. I have to relentlessly optimistic.
I am.
I'm
a cockeyed optimist.
Your tagline.
I look at this decision, and to me, I see a court unanimously removing all of these fines, these draconian fines that the Obama administration applied to nuns because they dared to defy an order to provide abortion and contraception services to the employees of their organization. They've removed that, which basically means, no, you can't do that, and that was wrong to do, number one. And number two, these justices unanimously determined that an accommodation of some kind needs to be made. Now, either you make the accommodation and work something out, or we will come back and we will put a ruling in there. But that is a message, me as a person who believes that organizations should have the right to practice their religion, whether they're an individual or a corporation. I believe that that's a victory because the court has said, of course, you can't force them to do this.
Larry, I love your sunny optimism. Now let me take a bulldozer to because Justice Sonia Sotomayor, joined by Justice Ruth Bader Ginsburg, wrote in a separate opinion. They joined the unanimous opinion. But then they warned everyone. They said, do not take this as any sort of vindication on the merits. They said, nor should you take this as any indication as to how this case would be decided on the final merits. Don't take this as an indication that the employers would prevail. So in essence, the message that was being sent was, we're not saying we're not going to fine you. We're just saying we're not going to fine you up until this point and until the litigation is over. You could still lose this litigation, and if so, you would be facing exactly the same disastrous choice. You would just be facing it maybe a year down the road.
Yeah.
Not now. They never said it was wrong to impose the fines. They never said they couldn't do it.
All right.
They never even said the government could do an accommodation. They just said we're sending it back down to see if those things will
Ken
happen.
Klukowski here to ruin our day.
Yeah, thanks for that.
Real fast, though, Ken. And
Always happy to do so.
Really, we only have 30 seconds, but this does amplify exactly how important this presidential election is because there's no doubt who Hillary Clinton would appoint to the Supreme Court.
No, that's absolutely right. If you were to get a 5th liberal justice to the Supreme Court, and we're not sure who she would pick, but if you were to get a 5th solid liberal justice to the Supreme Court, right. I think, as President Obama said yesterday, he was confident the case would have come out differently on his side, and he may be correct.
Yep, because Hillary Clinton would appoint a judge that would make a nun provide an abortion.
There you go.
That's all you need to know, all you never Trump people. Enjoy.
Ken Klukowski, thank you so much.